Hello everyone. I, Forum Patel from LG School of Law, would like to extend my warm welcome to every viewer. Friends, welcome to the fourth session of the advertisement segment under the media law. Friends, in the previous sessions, we discussed about the concept of the advertisement, misleading advertisements, law regulating the same thing, the protection of the consumer's right in that regard, then of course of the advertisement agency, that is ASCI, and the Advertisement Act. So far we have learned with all these segments of the advertisement and the legislation which is available to protect the same. So friends, when we are talking about the advertisement, we had mentioned that advertisement nowadays has been made through different forms, in different digital or rather any other forms other than print media, of course, which was one of the very traditional ways. So when we are talking about internet, to use that tool, we should have that question in our mind, that what do you mean by internet? How internet is relevant when we are talking about the advertisement segment? Friends, let's get started with the understanding of internet as the new media. So when we are talking about internet as new media, we must be asking ourselves that what is internet and rather what is new media, friends. Digital technologies has given birth to take the advantage of the computers and internet at the next level, my friends. Nowadays we are very well aware about the different social medias, which is blogs or online segments or online platforms that has been made available to us through the medium of the internet, so as to create the whole new world. Advertisement, of course, would be relevant when we are talking about the internet segment. The phrase new media is in relation to the old media forms such as the print, newspapers and magazines, etc. etc. That was the presentation through text or graphics. But when we are talking about the new media or rather internet, it would include websites, blogs, streamings, emails, online communications, different platforms on which we can share, mobile apps, web advertising or virtual reality world. It is a whole new segment, my friends. That is the reason internet has been known as a new media. Previously, my friends, in the few past decades, internet was not so much effective when it comes to having its own mindset on the public at large. But now, with the way too much increase in the usage of the internet, my friends, we surely can state that advertisement when it comes through internet has the largest impact on the minds of the people. Of course, there will be certain problem with regard to legal framework of the internet ecosystem in India that has captured the public attention over past certain years, with the media focusing particularly on the censorship and surveillance. But with these increased issues, the question would be same. What are the regulatory authority to govern the internet, even if it has become the new face of the media? Is it so easy to regulate the whole segment of internet? Friends, if you think so, then it is not that easy, of course. The wide phrasing of the provision that is ensured that it can be used to criminalize almost any behavior on the internet, and this has to be seen in the practice as various activists and others which has been arrested because of certain comments. We are not unaware from the fact of the section 66A of the IT Act, that is one of the very recent issues that has come up with restrictions on the freedom of speech and expression when it comes to internet. Even if it is new media, can you regulate the same? Can people have the same right as they had in the old media, or rather their rights have also changed? What is the nature? This is a very important and very interesting discussions, friends. The governments with this changing face of the time has also attained certain powers to even block the content on the internet or even to regulate certain websites. So would that fall within fairly broadcasting conditions, or rather it will be a mixed result, that is protection of the interest of the individual or rather protection of the state at large? What can that be? How the law can take any decisions in that matter? So that means, my friend, that social media also has become an inclusion in the new media. along with the internet. Social media is a platform which has been provided to all of us through the medium of the internet. So that can never be an exclusion, of course. When we are talking about regulating these platforms, we have different laws for the same. These laws are, as you can see on the screen, IT Act and of course the Constitution of India. So, friends, the issue of the censorship of the online content in India is a tricky question. Of course, the Constitution permits censorship in certain limited circumstances. It is, of course, there to regulate the problems. This is a problem which has been emerged due to the global nature of the internet. It is very difficult to control the content which is being uploaded on that segment. Further, the thorny issue who gets to decide to censor the content or under which circumstances it has to decide the same is still debatable. Of course, as we talked about, the past few years has been an explosion in the internet usage in India, with approximately 10th of the contrary population now considered active on the internet. While this increased access and use of the online resource is undoubtedly beneficial to the country as a whole or at large, there are of course certain numerous shortcomings ranging from the lack of the access or rather some certain lack of adequate infrastructure which are falling behind. Even the legal framework are there in the problem governing the whole internet ecosystem in India that we have. As we all know that Article 19(1) subclause A of the Constitution, it protects the rights to free speech and expression irrespective of the medium of the communication. While the courts have interrupted this right in a very broad manner, Article 19 subclause 2 at the same time permits reasonable restriction on the public policy concerns. Now, according to that and at the same line, the IT Act contains numerous provisions that can be used to censor the online content. As I stated before, notably as per section 66A, 69A and 79. Now, section 66A has been probably the most reviewed section of the IT Act on internet when it comes to the issues. Now, in the last year, due to certain arrest which was made under this section in Maharashtra in 2012, this provision criminalizes the practice of sending an offensive message through the computer resource. Now, whether giving an opinion would be considered as a criminalization process or rather misusing the platform which has been given to you, still it's a debatable matter. But in that case through which the section 66A was struck down is the notable one. That was Shreya Singhal case, my friends. In that case, it was stated that this section which criminalizes to put up the content on the media or rather internet through different platforms, it is harming the freedom of speech and expression, which cannot be allowed. And so, posting completely innocuous comments was not of course intentional, or rather it was not misusage of the provisions that led to the public interest petition which was being filed in the Supreme Court. And so that makes us with the two other sections, that is 69A and 79, which has received less attention from the public to be discussed. Now, these section 69A, which authorizes the government to block the content from being accessed by the public on various grounds. Now, an intermediary who fails to comply with the directions to block the content is liable, of course, for the imprisonment. The punishable crime, if it is, then it may extend to 7 years. This provision also ensures the government to block the content if it deems, or rather if it feels that it is falling fairly below the broad conditions that has been used, which has also received mixed views. The other section under IT Act, my friends, that is section 79 of the IT Act, which requires an intermediary observation with regard to certain guidelines in order to avail the exemption from the liability part. These guidelines mandate that the intermediary must take down the information that is inter alia grossly harmful, harassing or defamatory or even obscene in its own nature, which is libellous also under the law of torts, and it is intruding in somebody's privacy. So these are the sections of the IT Act which are there having an impact on the internet segment. Now when it comes to enjoyment of your freedom of speech and expression, of course Constitution of India is available right with us on our hands. So friends, the social media law is regulated by the Information Technology Act, which was enacted in the 2000 year to regulate, control and deal with the issues which is arising out of the IT, social networking media or entertainment or even advertisement segment within the meaning of the IT Act. The social networking site in India are liable for the various different acts which are punishable under the laws of the India. So friends, these are different issues which are arising from the segment of misleading advertisement, then internet as a new media, and of course we have the regulatory legislations for the same, which is IT Act and Constitution of India with us on our hand. We still have one bill in the pipeline, which is the Communications Convergence Bill, which is still to be yet to come, but we shall have look at the important segments of that bill which is to be discussed. So friends, we shall be discussing about that bill in the next session. Till then, stay tuned and keep learning.